Okay, here's another one of those obscure legal concepts with a Latin name that nobody understands and yet has deep implications in our society. This is the idea of respondeat superior. It literally means let the master answer. It's a concept from common law that sets up the idea of vicarious liability, that a party is responsible for the acts of its agents. What that usually means is employers are responsible for the acts of their employees. If a worker injures somebody or damages property while in the course of their employment, it's not the worker we go after the employer. They're the ones that set up the job and they're the ones that are profiting off of it. Therefore, they're the ones most responsible and most capable of compensating for injury. This is a long-running concept, and yet, as you can imagine, employers do not like the idea of respondeat superior and have found many ways to legally get out of their liability. The most common way is to claim that these aren't employees at all, but instead they're independent contractors, and that has been a very successful strategy. If you're in California, you may remember Proposition 22 a couple years ago that literally defined gig economy workers for companies like Uber, Lyft, Instacart as independent contractors, meaning Uber, Lyft, and Instacart as companies are escaping their liability of respondeat superior. They're saying these are not our employees. I wonder what all of you think about that. I know that California voters said, yes, we approve that. We believe that people who work for Uber actually are not employees of Uber. I know what the gig economy companies think. What do you think?